So on the one hand, they want to rein in the executive branch. On the other hand, now Congress basically doesn't exist anymore. And so the Trump administration is just like issuing executive orders like, we're deciding how much Ozempic costs today. And like tomorrow we're doing the, you know. Hello and welcome to the Bulwark podcast. I'm your host, Tim Miller. She's a professor of law at the University of Michigan. Second straight University of Michigan guest. Hail to the victors. She's
Go
also Go Blue. She's also co-host of the podcast Strict Scrutiny. She clerked for Anthony Kennedy, and she's the author of a brand new book, Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. It's Leah Litman. What's going on, girl?
You know, same old, same old. Everything is amazing. World is looking great. Yeah.
Who's got it better than us?
Right. Exactly. Thanks, Jim Harbaugh.
That's my sport reference for the day for you. Okay, I want to do book stuff and like get, kind of refresh my old Federalist Society originalist muscles from, my Republican days on the back half of this. But first, I just because there is so much going on. I've had several people like pitching me about when having me on the come on the pod to talk about upcoming Supreme Court cases, and I'm just like, y'all, talk to me at the end of May. Like, there's too much shit going on, like day to day, to like get into what's coming on the Supreme Court docket. But I figure this would be a good chance to just get a little overview with you of the big cases coming up, that we'll obviously be digging into deeper as the rulings are coming down. So, I just glanced out this morning. We got gender care for minors, gay kids books ban, Alien Enemies Act, Abrego Garcia. What jumps out to you?
Yeah, so I definitely think the Trump administration is doing the Supreme Court a real solid just by drowning out coverage of what they might be up to, because the court has a bunch of big cases on their docket. So there's the gender affirming care ban that you noted, United States versus Scrimeti. That's about whether laws that ban gender affirming care trigger heightened scrutiny, whether courts have to look closely at them or whether courts are just going to basically sign off on them. That could obviously have a ton of implications for a Republican-controlled Congress adopting a federal ban on gender-affirming care or on the constitutionality.
For minors, just for minors?
No, even for adults, because if the Supreme Court says laws that ban gender-affirming care don't discriminate on the basis of sex and don't discriminate on the basis of gender identity, then laws that restrict that care for adults would also get super deferential review. So yeah, that case could be hugely significant. And then they have the religion in schools cases. So there's the LGBTQ book case that you mentioned about whether parents can challenge a school district's decision to have storybooks with LGBT characters in them, because that apparently triggers Sam Alito as well as other religious and social conservatives.
Mrs. Alito, for sure.
Oh, yeah, for sure, for sure. And also apparently Neil Gorsuch, who read Pride Puppy and had an utter fucking meltdown. So he looked at this book, which is a puppy at a
Pride Puppy. Is that like someone in a pup mask at a pride?
No, it's a little dog at a pride parade. Okay. And teaching kids what you will find at a pride parade. And Neil Gorsuch looked at this book. There's a woman in a leather jacket, and he was screaming at the top of his lungs at the advocate, why are you letting kids look for bondage and sex workers and BDSM? And the advocate is like, that's a woman in a leather jacket, Neil. So there's that.
I'm glancing at some of the pictures now. Oh, there is the puppy has a little neckerchief. The neckerchiefs are popular with the gays, so that's not surprising. I'm not seeing any bondage here, but I'm just kind of glancing. So, wow. Okay.
Yeah. So there's that one. There's also a case about whether states have to create religious public charter schools. You heard that right? Whether states are required to create.
Required to?
Yeah.
Okay.
Yeah. Because Sam Alito, Brett Kavanaugh think it's actually unfair discrimination for a state to charter secular schools, but not religious ones. Yes, they are literally declaring unfair, unconstitutional the Establishment Clause, which heretofore had prohibited religious schools, but pay no mind.
Okay, we'll get back into the originalism on the back half of that, like how that fits with the originalism thesis.
Exactly. I could go on, any number of Trump cases might make their way back to the Supreme Court. You mentioned Alien Enemies Act and Abrego Garcia. Of course, the court is also hearing the big case about the birthright citizenship executive order, though technically the question they are asking is whether trial courts have the authority to block policies on a nationwide basis, or instead have to limit their rulings just to the states in which they reside or the states that challenged a policy. So that's a big case. There's a case that could kneecap what remains of the Voting Rights Act and whether it actually protects against districting that dilutes the political power of racial minorities. So many big cases. And again, the Trump administration is just drowning all of this out.
What about the Doge cases? Is any of that going to make it to the Supreme Court? Either like the probationary federal workers that were fired, or the access to the Social Security Administration? Like that stuff's still winding through the courts right now.
Yeah. So if it ends up at the Supreme Court anytime soon, it's going to be on the shadow docket or emergency docket. That is, the Trump administration or plaintiffs might run up to the Supreme Court asking them to put on hold some lower court ruling or asking for an emergency injunction. Those aren't cases the court heard argument in or full briefing that we're necessarily expecting a decision by June. That would be more on like a last minute basis.
But we are expecting by June something on Alien Enemies Act and the Venezuelans.
No, so I mean, not necessarily. It really depends what happens in the lower courts, because the court hasn't granted for full review any Alien Enemies Act cases. But of course, these cases are developing so quickly in the lower courts, it's super possible something ends up there.
Yeah, it's interesting because I was one of the immigration lawyers I've been talking to said that there was like something that there was an encouraging development about how, some of the Venezuelans that have been sent to SCOTUS were like granted, to be part of the, what's the fucking legal term? Part of the group, part of the
class action,
part of the class. Thank you. I need a second cup of coffee this morning. Part of the class, but then there's it was another court ruling that I guess is calling that into question. So I guess like who has standing and who's part of all of that is kind of tricky when it comes to people that are not like technically here legally, which was the case for maybe not all of the Venezuelans, but most of them.
Yeah, so the Supreme Court basically created this situation where individuals in different states, they all have to challenge their potential expulsions and detentions because the DC District Court, he had blocked the Alien Enemies Act nationwide. But the Supreme Court said, no, you can't do that. Every individual has to litigate their case in habeas class actions. And so those rulings are going to be limited to, anyone who's detained in a particular district or state. And so, yes, people in some places are protected, people in others aren't. And that's why the Trump administration is like trying to move people between jurisdictions to get them into places where they aren't protected. And yeah, it's just crazy.
Just like kind of looking back what they've done so far this year, whenever I have a legal person on, there's kind of a variety of views on just like how catastrophic it is, versus like, well, actually they've, in a couple places, particularly Amy Coney Barrett has shown some surprising pushback on the Trump administration, particularly in the Abrego Garcia case and some of these immigration cases. Like, what do you make of what we've seen so far this year as far as these kind of shadow docket cases?
Yeah, I think thus far, honestly, the Supreme Court has tried to avoid any big rulings and tried to defer saying anything that big about the Trump administration. Yes, Justice Barrett has occasionally joined with the Democratic appointees, and Chief Justice Roberts on some matters. But even when the court has ruled against the Trump administration, they've given the administration some wins and some wiggle room to work with, like in the Abrego Garcia order, or even in the United States Agency for International Development case. They waited to release their ruling until after the government was under obligations to actually pay out the funds. So anyways. So they have ruled against the Trump administration sometimes, but avoided doing so in pretty pointed or harsh ways.
All right. The other big kind of policy legal cases that are coming up as far as active Trump policies is the trade case. I guess yesterday, this is outside of the Supreme Court wheelhouse. There was a 3-judge panel on the Court of International Trade that held the first some oral arguments on the cases challenging the legal basis for Trump's administration's tariff framework. I guess there are at least 7 of these cases out there trying to nullify Trump's tariffs. What do you make of that? Like whether that is something that like might possibly happen, or what do you think of the merits of the trade cases?
Yeah, so it's a tough case because presidents have been granted, substantial powers under the International Economic Emergency Powers Act, as well as over foreign trade and tariffs more generally. And so I think the court at that hearing were very nervous about trying to second guess the president's determinations about whether there was an unusual and extraordinary threat, even though Donald Trump's claims for why there is are just insane. Like the trade deficit has existed for a really long time. That's neither unusual nor extraordinary. But the court didn't seem to be comfortable with any kind of rule that the lawyers challenging the tariffs had offered for when courts could say something wasn't actually unusual or extraordinary. And then there are the host of doctrines and rules that the Republican appointees on the Supreme Court have come up with, like the major questions doctrine, the idea that agencies can't do anything that big, under statutes that are generally worded, or the non-delegation doctrine, which is supposed to limit the extent to which Congress can confer authority to make regulations on non-legislative entities. The problem is the Republican justices have basically created these rules that gerrymandered in exceptions for things Republicans wanted to do. So the major questions doctrine might not apply to the president, or the non-delegation doctrine might not restrict the president's ability with respect to foreign affairs and trade. And so it's unclear to what extent at all these doctrines that the Supreme Court invented are going to be much use in these cases.
Yeah, and I guess maybe this transitions us to the book a little bit, but just on the merits of the interesting example of what you're just laying out is this Chevron doctrine, the Chevron case, right? Where like kind of simultaneously, the Supreme Court has said that the agencies, cannot like do things that are not specifically legislated via Congress, and it was basically an attack on like the EPA and these other agencies who had there was broad funding about what kind of regulations that they were going to do, or broad language about what kind of regulations they could do, and then there's this kind of deference towards the agency heads and what that could mean, and the conservative Supreme Court wanted to rein that in and force like Congress to be very specific about what those regulations are. So on the one hand, they want to rein in the executive branch. On the other hand, now Congress basically doesn't exist anymore, and so the Trump administration is just like issuing executive orders like, we're deciding how much Ozempic costs today, and like tomorrow we're doing that, And so, how do you sense that the court is going to kind of balance those two, or maybe they're not going to try to balance?
Yeah, so I think there are kind of two different things going on. One is, I agree with you, there's always been this ridiculousness in the Supreme Court's insistence that they are going to somehow teach Congress to legislate. Like, if only the Supreme Court justices undid Chevron and adopted this major questions doctrine, then of course Congress would just buck the fuck up and start passing more legislation. And it's like, how delusional are you to think that you could single-handedly do this? Like, it's not about you. And yet they still cling to this fantasy world that just does not describe the reality that we are living in. And then, they have also, while they have been skeptical of administrative agencies like the EPA, they have simultaneously been very pro-presidential power. And these things, sit in uncomfortable tension with one another because, of course, the idea that an administrative agency can't do shit because it's not the legislature could also be said about the president, and yet doesn't seem to give them any pause. And one more thing just on Chevron. This is just like this perfect, like, you were for it before you were against it. I mean, Chevron was originally this Republican supported doctrine because it was announced in a case involving the Reagan's EPA. And guess who was the head of the EPA at the time? Neil Gorsuch's mom, Ann Gorsuch Burford. Yeah.
Miss Gorsuch, Ann.
Yeah.
I didn't know that.
Yeah. So I kind of write about this in the book as like part of Neil's villain origin story. Like, his mom got chased out of the EPA, and this apparently has given him a complex against the administrative state, which he's been out to get ever since. But yeah, no, it was really wild. In the oral argument about overruling Chevron, the lawyer who was challenging Chevron was asked, do you want to keep the result in the Chevron case? And he literally said, well, with respect to Justice Gorsuch's mother's EPA, I think she got it right, basically. It's so wild, like, how messy that entire scene is.
So what was the original, like, it was Gorsuch's mom as the Reagan EPA administrator was going further than Chevron, the corporation, thought was, and so they're challenging the rule, the regulation, I guess.
Well, so yeah, she was deciding basically when power plants needed permits in order to construct new pollution emitting devices under the statute. The statute has rules. It's like, okay, if you make a new device, new stationary source, like you need a permit. And she said that doesn't include when an existing power plant makes new pollution emitting devices like within the power plant, as opposed to making an entirely new power plant. So yeah.
That's interesting. So this is related to kind of what I wanted to talk to you about. I mean, I was challenging old David French about this a couple weeks ago, and maybe we can continue to hash out this conversation in the weeks ahead. But to me, like, I don't want to say that there never was any coherent, genuine, ideological, conservative view of the court. Like, obviously, there are always debates on the right, but the originalists or the people that are Scalia or whatever, that there's nobody ever that had, coherent view of like what the court's role was, in relationship to the Constitution. Because I think that there was some of that. But I think that as we've gotten into the Trump era, what has been revealed is that similarly to across many other elements of conservatism, it was a much more about power than maybe they wanted to let on or wanted to even believe themselves going back. And that what we're seeing now is a lot of the conservative legal movement kind of backfilling like the rulings that they want or the political outcome that they want, and then pushing for a ruling that supports that, regardless of whether it fits within, whatever your constitutional rubric had been, during the Reagan era. What do you? I mean, obviously, I think you believe that, but could you kind of hash that out and how you get into it in the book?
Yeah, definitely. So the first chapter in the book is partially about the rise of originalism. And I'm definitely sympathetic to the idea that for some people, originalism was this kind of pure, on its own, inherently correct method of interpreting the Constitution. But originalism to other people was also this intuitive way of explaining why certain decisions of the Warren Court, as well as Roe versus Wade, was wrong, right? Like they knew, they had an intuition that, of course, these things cannot be correct. And originalism was an easy way of explaining why that was so. And then for other people, originalism was a way of advancing an ideological agenda. Ronald Reagan's Attorney General, Ed Meese, just stood up in front of the ABA and was like, yeah, originalism, that's a way to roll back civil libertarianism. That's a way to advance, our traditional social issues platform. That's also what Stephen Markman, who was one of the assistant attorney generals, wrote about originalism again in the 80s. So I think originalism has always been different things to different people. And like any method of interpretation, it has its virtues and it has its vices. It was sold as it's principled, it's neutral, right? It's easier to apply than other methods. I think those things are debatable, but that's not to say people didn't believe them. And that's not to say people weren't pushing originalism, for never those reasons. So, I agree with you that originalism, textualism, any method of interpretation is always going to appeal to some people just on its own terms. But yeah, then along comes Sam Alito, and you put any method of interpretation in his hands, and he's going to do whatever the fuck he wants with it. And, the Republican judicial selection machine found enough people like that and perfected the process such that they could give them this tool that sounded really nice in judicial confirmation hearings and sounded objective and could be explained in, again, like abstract technical ways, but everybody knew what they were going to do with it.
Yeah. I mean, you can describe it in the title there as bad vibes, right? As how they're going to justify this. And certainly there's some bad vibes around this Supreme Court, specifically, around Mrs. Alito.
She is a bad vibe.
She is like a human bad vibe. I look at all this and I was like paging through it. And to me, it's like, honestly, I think what we've learned over the past 5 years is that everything, it's like culture all the way down. Like everything is about kind of like an imaginary or real in some cases culture war that they're in.
Yes.
But sometimes it's a real cultural war over real issues, and sometimes it's kind of this imaginary, I don't like these other guys, and it's more of like a high school cafeteria like rival gang type thing than anything actually deeper. And it's like we've now seen in the Trump administration, like he has shat on every single like supposedly principled constitutional argument imaginable. He shat on every free market argument that every pencil head on K Street ever pushed over my entire life, and yet 96% of the people, including most of the Supreme Court, with TBD on Amy Coney Barrett, like has just gone along with it. And it's and then to me it's just because it's like my side good, the other side bad, and it's like really not much more than that.
Yeah, no, I mean, I definitely think there is some aspect of that. And I think when you say it is about culture, I view the Republican appointees on the Supreme Court as being acculturated in this like conservative grievance industrial complex that has taken over the Republican Party. That is the energy that defines them. They view, Democrats, progressives, anyone that doesn't agree with them as attacking them and coming after them. And so they have made the law kind of fashioned based on the emotional needs of at least 5 men and maybe Amy, right, who believe that equality is actually a form of discrimination, and calling racial discrimination is actually discrimination. Like, it's just this nutty kind of worldview where they have such strong main character energy that they can make, again, LGBT storybooks about them. They can make the Establishment Clause into rank discrimination against, religious and social conservatives. And so when that is the worldview that they were socialized in, and when that is what is being repeated to them in this media ecosystem and political and cultural network that they are a part of, that is, I think, how they perceive most of the cases and many of the issues that come before them.
Yeah. Let's talk about the FedSoc role in all of this, because there also kind of exists two FedSocs, right? Like there are lawyers who go to random schools, go to random law schools in the country and have more conservative legal views, and they join little FedSoc clubs, and it helps them get hired for jobs. And then there's like the DC Feds, and there's some overlap there's some bleed between the two groups, right? Then there's the DC FedSoc, which is Leonard Leo and the political activists that have pushed this grievance culture that you've laid out, and tried to place the people from the clubs who I think most fit their grievance ideology into powerful positions. So I just talked about how important that is in this whole, and what you get into in the book.
Definitely. And I hear a lot of what you are saying in the comments that I see on social media from many of the lawyers who are in the Federalist Society, but not in, the inner circle of the Federalist Society, because they'll make jokes about how, well, Leonard Leo didn't tell me, who I should vote for, or Leonard Leo didn't tell me what I should think. And it's like, that can be true, right? Of course, they run all of this programming where they are not necessarily getting to know every single lawyer who attends all of these bar association events, right, in random cities, right, and at different schools throughout the country. And yet that is also part of what gives them purchase and cover, to do the other things that Leonard Leo is doing. Because if you don't understand how this debating society, right, and how this institution that just provides forum and networking can also be engaged in this system of selecting nominees, figuring out who's going to do the things they want to do, then you are kind of getting the wool pulled over your eyes. And so I agree, it can do both. It just so happens that doing both things operates to the benefit of the inner circle part.
Right. It gives them more power and influence and allows the malign parts of the group to essentially put people in these extremely powerful road positions where they have control over massive decisions that influence the whole country. Right. And so I don't know. I say this sometimes to like college campuses when I speak on, and it's like, well, some of my candidates that I worked for, looking back on my time in the Republican Party, were good. I still like, right, or good people, and I think would probably have good judgment. And yet, like, if you find yourself as part of a group and you find yourself having to say, well, my little corner of the group is good, like that's maybe should be a sign that the group that you're in isn't that great. Like maybe there's a splinter effort you should consider.
Right. Totally fair point.
What do you make of this? I think that the Souter, the appointment of Souter is maybe something that hypercharged something. I agree. We were always on this path, right? Like we were on this. Our whole culture, our whole society has been politicized. So eventually, the Republican legal movement was going to be politicized more and more over time. I feel like that's inexorable. But the case of Souter
haven't really picked up on that just yet.
Okay, that's a great point. Why is that, do you think? Then we'll get to Souter. Why hasn't
this is one of those things where I feel like I'm not on the inner circle. I'm not in the inner network, so I don't have real insight into this because I'm screaming at them all the time to like get with the program, and yet they're not listening. This inner circle operates very differently.
Yeah, there are a lot of things that have been politicized on the left, no doubt, but certainly the legal argument, like from this sort of rubric, like the institutional legal world has been politicized on the right. Like it's insane. You can't even compare it. It's not even the same ballpark. But so Souter gets appointed to the Supreme Court, and ends up, siding more and more with the liberals over time. When I was coming up in Republican politics, there was just this conventional wisdom, right? It's kind of part of this anti-elite sentiment, right? Like we pick these elites, they go to these elite liberal Ivy Leagues, they say they're conservative, but they get to DC and they start going to the cocktail parties, and over time they start to get more and more liberal, and like that served as the rationale for, we need to be more aggressive about identifying people that are going to be part of our culture war, part of our grievance war, part of on side at all times. And I don't know. What do you make of that? Like kind of the Souter experience hypercharged the appointment of these more kind of partisan ideological judges.
Yeah. So
I don't mean to blame David Souter about this, who also just died. Rest easy, King. It wasn't his fault. I'm just saying it just happenstance.
It is not his fault at all. But in addition to this fueling a desire to select individuals who they knew better and thought would be more reliable votes, it also fueled them wanting to throw their own cocktail parties, right? And offer the justices their own PJ trips and create, an alternative media ecosystem so that they would receive their claps, for doing the things that the conservative legal movement wanted them to do. And so that's also, part of the story of the post-Souter
social incentive structure, an anti-Georgetown cocktail party circuit. Exactly. I love that. That's a great point.
Exactly. But yes, this is part of the tragedy of David Souter, who is an independent jurist who did really care about the facts. And in my view, is someone who I would describe as a real small c conservative judge, right? Like very incrementalist, didn't want to do real shockwaves through the law. And soon after he is appointed to the court, he decides not to overrule Roe versus Wade. And that is what sets off these calls of no more Souters. And that spawned, the kind of increase in the Federal Society's focus on identifying nominees who could be trusted, as well as, creating this social incentive structure and professional incentive structure for them to do, the quote, right thing. I don't know why the call ended up being no more Souters rather than no more Kennedys, because like he did it too, and he had initially voted to overrule Roe and then changed his mind. But
he was Catholic, I think. Honestly, because I think there are a lot of Catholics in this world, and I just think that he is more so like culturally felt more like one of them than Souter did, who kind of felt like this like Northeast defeat, like fucking, Rockefeller Republican or whatever from a different time.
Yeah. And then of course they didn't scream about Justice O'Connor because she's a woman. And so of course she couldn't be counted on to do the right thing.
And Reagan picked her.
Right.
What, that's a good point. Talk to about Kennedy. Do you have any, how was he able to buck this? Do you have any memories or any thoughts about Justice Kennedy?
Yeah. So obviously I was not there, during Planned Parenthood versus Casey. But I think, he has real views about what the Supreme Court is for and is very sold on a perception of the court as this independent, neutral arbiter in certain ways. And so the political movement to overrule Roe versus Wade, I think, made him uncomfortable, because this is not a man who was at all, right, like pro-choice or sympathetic to the arguments, about Roe versus Wade. I mean, he wrote anti-abortion shibboleths into the U.S. reports when he said, without evidence, he conceded there's no data to back this up. He said, of course, like most women come to regret their abortions. So
Sure.
I think that, it was really his sense of the court and his desire for it to be independent of politics that probably pushed him and Casey.
Wow. How refreshing that is. What a different time.
Exactly.
A Supreme Court justice that's like, I'm going to do rulings that go against my personal views because I feel like that's what the law says. That feels quaint.
It sounds like a fiction book to me.
Seriously, definitely not from our era. All right, do you have any? I guess how about one more for you? What's the setting aside Dobbs? And well, I guess let's do a medal stand. We've got Dobbs, and we've got telling the president that he's immune from crimes. What would you say is the third decision that is the most representative of the conservative grievance fringe theories and bad vibes of this Supreme Court?
Man, you're really going to make me pick one. Okay, I'm going to pick two, and I'm going to call it a tie.
Well, fourth person medal stand, there's like a shorter stand for number 4 on the side.
Exactly. You always need a first runner up. Yeah. So 303 Creative versus Olenis, the recent case where they said violated the First Amendment to apply Colorado's civil rights law that prohibited discrimination on the basis of sexual orientation to a wedding website designer. Yeah. And the reason why I just think that is like perfect conservative grievance, cannibalizing the law, is first they insist, well, this case doesn't involve discrimination on the basis of sexual orientation, because sure, she wouldn't make a website celebrating a same-sex wedding, but guess what? She wouldn't make a website for a straight couple that also wanted to celebrate a same-sex wedding. And it's like, get the fuck out of town. I
love these cases. I'm always like, every time I got in a fight with somebody over this case, I was like, I would be on your side if you can find me a single case of a baker or of a wedding website maker who would not make a website for someone who's on their 4th wedding, a straight couple who's on their 4th wedding, or like a straight couple who's on that does some other violation of, or a straight couple who had premarital sex. Like if you can find me one example of this, then I'll maybe consider your arguments that it's not about discrimination. But it's hard to find one of those. It always seems to be the case.
Exactly. Yeah. And at the same time, they say, well, definitely not discrimination on the basis of sexual orientation. It is discrimination against religious and social conservatives, because that's really what equality is. So yeah, vibes all the way down, conservative grievance, etc. Then I'd say law of democracy cases like Shelby County versus Holder, where they just announced that the Voting Rights Act unconstitutionally discriminated against the former Confederacy, like turning a case involving racial discrimination into one where the former Confederacy is the real victim. Wow, that's real galaxy brain conservative grievance.
Yeah, well, white farmers in South Africa and the former Confederate states are the real victims in our society. Leah Litman, thank you so much. The book is Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. The podcast Strict Scrutiny I also really love, so go check that out. Go Blue. Appreciate you coming on the pod, and enjoy the book tour.
Thank you so much for having me. I appreciate it.